Good afternoon, and thank you for joining this webinar on guardianship issues in Washington State. Today, we'll review the basic legal framework governing guardianships under Washington law, when guardianship may be appropriate, and some common issues people encounter in practice. Washington substantially updated its guardianship laws in 2022, and it now emphasizes protecting the autonomy and rights of individuals while still allowing courts to intervene when someone is unable to adequately protect themselves. In today's short session, we'll cover what guardianship means under Washington law, when guardianship is appropriate, the guardianship process, and practical issues guardians often encounter. Let's start with what a guardianship is. Guardianship is a court-supervised legal relationship in which one person is appointed to make decisions for another individual who's unable to manage certain personal and financial aspects of their lives. Washington law distinguishes between two roles for someone who makes decisions for a vulnerable individual. First, there's a guardian who makes decisions related to personal care, health, safety, and living arrangements. There's also a conservator who manages financial affairs and property. Another important concept is that guardianship can either be limited, meaning authority granted by a court is restricted to certain decisions, and full guardianship, meaning a broader authority is granted. Washington courts strongly prefer limited guardianships whenever possible to preserve as many civil rights for a vulnerable individual as possible. Key goals of Washington guardianship law encourage finding the least restrictive alternatives to be used to assist vulnerable individuals subject to guardianships. In addition, Washington law seeks to preserve individual decision-making authority, increasing court oversight, and expanding due process protections for the person subject to a guardianship. For example, vulnerable persons subject to guardianship now have clearer rights to legal representation, participation in hearings, and the ability to challenge guardianship petitions. This particular topic is extremely important. When is a guardianship appropriate? A guardianship may only be ordered by a court when a court finds that a person is legally incapacitated and unable to manage essential personal or financial affairs. The key factor to focus on is a risk of harm to a vulnerable person. This can include somebody's inability to meet basic health or safety needs, someone's inability to manage their own finances, resulting in significant financial harm, or someone's vulnerability to exploitation or abuse, whether that's physical or financial. The main message I hope you'll take away is that making poor decisions alone does not mean someone is legally incapacitated and is therefore subject to guardianship. For instance, just because mom has received a diagnosis of mild cognitive impairment at the doctor's office doesn't mean she necessarily lacks legal capacity, and thus you don't have the right to take over control of her finances or move her into an assisted living facility over her objection. Courts fully recognize that adults have the right to make decisions others might view as unwise. Vulnerable adults are not children whom we can automatically tell what to do. A guardian's duty is to protect a vulnerable person from self-harm or the harm from others. So for a guardianship to be granted, the person filing a guardianship petition generally must present clear and convincing evidence that court intervention is necessary to protect a vulnerable individual. Let's talk about the types of guardianships that exist in Washington. There are several arrangements, the most common of which is a limited guardianship. And this is where a guardian is granted authority only in specific areas, such as to make healthcare decisions or housing decisions for a vulnerable individual. A full guardianship gives broader authority, but it's typically only used when a person is unable to make most major decisions independently. Washington law also provides for emergency guardianships, which may be granted when immediate intervention is required to prevent substantial harm. But these orders are only temporary and designed to stabilize the situation until a full hearing can occur. Again, Washington courts genuinely try to craft guardianship orders that remove the fewest rights necessary from a vulnerable person. What kind of rights are potentially affected by a guardianship? Guardianship is a powerful legal tool because it can limit or remove significant civil rights of a vulnerable person. Depending on a court's order, a person under guardianship may lose authority over major decisions such as their own medical treatment, living arrangements, financial management, the ability to enter into basic contracts like signing a cell phone contract with a carrier, and in some cases, even voting or marriage decisions. Because these rights are deemed fundamental, courts approach guardianship very cautiously to ensure that the rights removed are only to the extent necessary to protect the individual. This is why Washington courts increasingly favor limited guardianships or even non-guardianships alternatives when feasible. Let's look at some of those less restrictive alternatives. Before imposing a guardianship, Washington courts are statutorily required to consider whether less restrictive alternatives could adequately protect a vulnerable person. Some of these common alternatives include having a vulnerable person execute durable powers of attorney, which allow individuals to appoint someone to manage financial or healthcare decisions, or executing advanced healthcare directives to allow someone else to convey a vulnerable person's written end-of-life wishes to doctors. Another less restrictive alternative is having a representative payee arrangement for Social Security and VA benefits. Finally, a vulnerable person can create trust structures such as special needs trusts that allow someone else to manage assets while preserving a vulnerable person's autonomy. If these advanced planning tools can address the underlying risks, courts usually decline to impose a guardianship. However, all of these less restrictive alternatives require a vulnerable person to have sufficient legal capacity to sign binding documents. If a family waits too long to seek legal help, these less restrictive alternatives may no longer be available. How does a guardianship start? The guardianship process typically begins when someone files a petition in Superior Court. This person is called the petitioner. The court then ensures that a vulnerable person who might be subject to a guardianship, that person is called the respondent, receives notice of the petition and appoints an attorney to represent the respondent's interests. Washington courts will also appoint a court visitor who investigates the circumstances, interviews the relevant individuals involved in the vulnerable person's life, and provides formal recommendations to the court regarding whether or not a guardianship might be appropriate. After this investigation, the court holds a hearing where evidence is presented. If the court finds that a guardianship is appropriate, it will issue an order specifying the scope of the guardian or conservator's authority. It's notable that guardians are subject to ongoing reporting and oversight by the court on at least an annual basis and usually more frequently. What are some of the common challenges that we find in guardianship practice? Guardianship proceedings often involve complicated dynamics. The most common issue is family conflict, where relatives disagree about whether a guardianship is even necessary or who should serve as a guardian. Another issue we see is overly broad petitions, where a person seeking a guardianship on behalf of a vulnerable individual seeks more legal authority than is really necessary. For instance, if mom can no longer balance her checkbook, but she can still vote, a limited guardianship would likely be more appropriate than a full guardianship. Financial exploitation is also a concern, particularly when significant assets are involved. It's often said that money brings out the worst in people, and sadly, there are predators who seek to become the guardian of a vulnerable person so that they can use that person's bank account as the personal piggy bank. Additionally, many counties face a shortage of professional guardians to help vulnerable individuals who don't have family members to serve as their own lay guardian. But the good news is that Washington has developed a robust public guardianship program to address this gap for vulnerable adults. I'd like to close with a few recommendations for best practices that can help ensure guardianships are used appropriately. First, if you're petitioning for a guardianship for a loved one, always evaluate those less restrictive alternatives before pursuing a guardianship. Second, if a guardianship is deemed necessary, Tailor the requested authority narrowly to preserve as many rights as possible for your loved one. Third, ensure that the evidence of legal incapacity is carefully documented in your loved one's medical file. This means that a doctor has determined that a vulnerable person has lost functionality to make his or her own decisions, and not just that she's making bad decisions or is sometimes forgetful. Remember that the ultimate goal of guardianship law is not control. It is protecting vulnerable individuals while preserving their autonomy whenever possible. Thank you for joining us today for this webinar. If you'd like to consult with me, feel free to reach out and I'd be happy to answer your questions. Have a great day.